All right, good afternoon, everybody. Thank you so much for joining today's webinar. My name is John Finch. I am the director of Able United, Florida's Able program. I'm so glad you're with us here for a very special Ask Me Anything session with a good friend of mine, a person I know well, who's highly regarded in his field, Jason Neufeld. Welcome. Thank you for being here today.
Wait, if John tells me to be somewhere, I'm there. Thank you, John, for inviting me.
Awesome. Well, Jason, he's a board certified elder law attorney here in the state of Florida. He's the founding partner of Elder Needs Law PLLC. He practices primarily on helping families navigate some of the most complex issues in elder law and special needs planning. Jason works includes Medicaid planning, estate planning, probate administration, with a particular emphasis on protecting income and assets while preserving eligibility for critical public benefits. Besides that, Jason, if he's not doing that, he's busy working in a variety of capacities. He's the president-elect for the Academy of Florida Elder Law Attorneys, co-chair of the Broward County Bar Association's Elder Law Section, vice chair of the Miami-Dade Bar Association Elder Law Committee, all-around great dad, husband. I mean, I don't know what else to say about you, but just want to say all the accolades. This is a person that is really high regarded, does a great job. I've ran into other attorneys saying that he's mentored them in this field. So just appreciate that what he's done here for the state of Florida. So
Thank you, John.
awesome. Before that, I want to kind of just give a brief overview of ABLE accounts because you'll see how some of that kind of plays into our discussion today and how that may be something you could take advantage of. So high-level ABLE accounts are tax advantage savings accounts designed specifically for individuals with a disability or severe diagnosis. It allows individuals and their families to save for qualified disability expenses such as housing, transportation, healthcare, and all to do that without negatively impacting benefits like Medicaid and SSI. Cool thing is contributions going after taxes, they go tax-free, and they can be really flexibly used for a variety of expenses. And so I know during the registration process, we said, hey, go ahead, put your questions in the box. There is going to be a Q&A or a chat box for you to ask questions as well. We'll do our best to get to as many questions as we have, but I know it's a lot. So with that being said, Jason, let's dive in. Let's just tell us high level, all right? I mentioned a lot of what your practice does, what you do specifically. Give us your elevator pitch when it comes into what you do and what all this means.
Yeah, so certainly on the easier side of the spectrum, not easier, but more commonly well known, there's the estate planning and probate, right? Is who can make decisions for you if you're unable to make decisions for yourself? Who gets your stuff after you pass away? How do we make that happen in the most efficient way possible? And if you haven't planned to make it more efficient, then there's a sort of a probate administration process that we can shepherd our clients through. A little bit less well known is the Medicaid planning side of what I do. So I work with people who typically they have too much by way of income or assets, and they don't want to have to go through all of that before they would naturally qualify for Medicaid to pay for care at home or pay for care in an assisted living facility or a nursing facility or expensive prescription. So I'm able to legally and ethically protect their assets so that they don't have to run out of money. They don't have to wait 5 years. They don't have to sell their house, and they can still get the government to come in and help cover some of those costs.
Wow, that is a lot. So I know when we put out that question, there was a lot of questions and anxiety around protecting benefits while planning for long-term care, especially around Medicaid eligibility, things called look-back periods, nursing home concerns. So let's just divide some of this. And can you help us understand the core principles families can keep in mind when they're starting to think through Medicaid and SSI and maybe well-intentioned decisions that can create some problems?
Yeah, I think there's a few. I'd say the two biggest misconceptions, and we'll tack them both separately, is there's Medicaid that you get only because you happen to receive SSI. But there's so many people in the state of Florida who don't qualify for SSI just because they make too much money, but they can still get Medicaid to pay for healthcare expenses or long-term care expenses. So that's number one. The other is the the probably the biggest misconception in my world is the 5-year look back period. And I'm going to start with that because it's just like the most common. I think the reason this concept being misunderstood is responsible for Floridians missing out on hundreds of thousands of dollars worth of potential benefits. So here's the misconception. Here's the incorrect statement. I cannot get onto Medicaid if I have too much money unless I wait 5 years, unless I spend all my money over the next 5 years. That's not correct. That is not what the 5-year look back period refers to. Again, clients come to me, they might have hundreds of thousands of dollars in the bank. They may own their house. And if all my clients had to wait 5 years, I wouldn't have very many clients. So clients come to me because they don't want to wait 5 years and they have too much money. They don't want to go broke first. So we have these tools that within a few months, not years, a few months, we can legally and ethically maneuver our clients' assets in a way that will, again, I always emphasize legally and ethically get them eligible for these programs just within a few months. And I tell people, we don't hide things. In other words, when I'm submitting a Medicaid application on behalf of my client, I'm telling DCF, the Department of Children and Families, you're going to notice my client had $350,000 and owns a house. And now that client has $2,000. Here's what we did with the money. And here's the corresponding state and federal rule that says what we did is okay. What we didn't do is gift the money away. That's what the 5-year look back period refers to. All Medicaid cares about, are you giving money away? If you start off with 300 grand, you can't give $298,000 away to your kids so that they hold on to it for you. If you do that within 5 years, you're going to have a big problem. But everything that we're doing is designed to avoid, it's moving the money away in a form that is not counted as a gift for Medicaid eligibility purposes.
That's a great point, because I know that's a question we get, especially now. So for those unfamiliar with ABLE, historically, we served a lot of more children or people who had a diagnosis or disability prior to age 26. At the beginning of the year, that changed. And so now we have up to 46 where that severe diagnosis
Correct.
or disability occurred. And what's been unique, I know on my end, I'm getting a lot more of that, hey, is there a five-year look back when it comes to ABLE accounts, or can you explain that? And that's where I'm like, let me find somebody that's an attorney and point you in that direction.
And really importantly, I think people also misunderstand this. It's not that you have to have been receiving Social Security disability or SSI since before turning 46. It's you have to have a disability that arose, that came into being before you turn 46. Obviously, if you have the SSA designation of disabled before turn 40, that makes it super easy. But if you don't have that, that doesn't necessarily mean it's impossible to qualify for ABLE. If you're coming to me, you're 70 years old, or let's say 62 years old, you never formally received the disability designation by Social Security, you can still go through a process by which you can show that you were disabled for a good long time and are now ABLE eligible.
Okay. Yeah, that's a great point. So let's talk a little bit about shielding assets, right? Because typically when people think of Medicaid, they're like, oh, okay, I can't have any money, right? No money in my name. It has to be in somebody else's name. Can you speak a little bit, like how do you go? What are the tools that you use to kind of help people shelter those funds so they can receive that Medicaid benefit?
Sure. Well, first, there's some basic principles that are important to understand. We get to start off with the fact that not all assets are considered countable assets in terms of determining whether someone is or is not eligible for Medicaid. We also have to make some distinctions, because assets that are automatically protected from Medicaid separate from SSI is different than what SSI considers to be a countable asset. So the biggest example that I can think of is a qualified retirement account, like an IRA or a 401k, right? If you have Medicaid, which again can pay for health insurance, it can pay for long-term care, whether it's at home or in a facility, that's not associated with SSI, a 401k or an IRA is not a countable asset if it's paying out regular distributions. Okay, so the income count, we'll talk in a moment about how we deal with that. But someone can come to me with, I don't see this a lot, but if someone came to me with $2,000 in the bank and $750,000 in an IRA that's paying out they might already be eligible for Medicaid from an asset perspective, protect, not SSI, but Medicaid independent of SSI. Okay. So we have in Florida, we also have some unique asset protections built in that are different than other states. So, for example, the homestead, generally not counted as an asset when determining whether someone is or is not eligible for Medicaid. Now, SSI, that's sort of a universal principle, but in Medicaid independent of SSI, fairly unique to Florida. Okay. Qualified retirement plans, Medicaid independent of SSI is a protected asset. We also don't have to worry about things like wedding rings and personal property and your furniture and silverware and things like that. Those things are not counted as assets when determining whether you are or are not eligible for Medicaid, which is very important. So now sometimes people come to me and they, hey, we're a lot closer than we originally thought to Medicaid eligibility. All right. The next thing I'm looking at is my client married? And do we have a situation where we have one spouse who would benefit from care at home or care in a facility, and the other spouse, who in our world we call the community spouse, is healthy? In other words, not in need of care in a nursing facility or home care or assisted living. If we have that set situation, then we get an additional $162,660 allowance. It's called the Community Spouse Resource Allowance, and it's only applicable when we have a married couple, one's healthy. That healthier spouse is allowed to keep, as of 2026, $162,660. So again, now we have a situation where a married couple comes to me with, let's use easy numbers, $164,000 between the two of them. They might already be eligible for Medicaid because we can just sort of move what we're allowed, the resource allowance, over to the healthy spouse. Now, we don't always have that, or we have both spouses who need Medicaid, or we have a single or widowed individual who would benefit from care at home or care in a facility. After we're done saying, okay, we don't have to worry about the homestead, after we're done saying we don't have to worry about qualified retirement accounts, and they still have $50,000, $100,000, $500,000, $600,000 sitting in the bank or sitting in a regular investment account, now what do we do? Well, now we have a whole suite of tools. I'm the first to say everything I do has a drawback to it. I don't have a perfect solution, right? I don't have like a special place I can just stick the money that you have full access to, that has no tax consequence, that has no Medicaid estate recovery consequence to it. Everything I do has a drawback. Yeah. But usually we're able to, not picking one thing or the other, we're layering strategies on top of each other, such as personal services contracts, where we can pay typically family members in advance for the work that they're doing anyway. We have special needs trusts, where I think we'll get into more in a moment, but that might have a Medicaid estate recovery drawback to it. We have Medicaid compliant promissory notes, which is one of my favorite. We have real estate investments that we can make, because in addition to owning a homestead, Medicaid in Florida, again, independent of SSI, SSI doesn't allow for these things, but Medicaid that's not dependent on SSI eligibility, you not only can have your homestead, but you can have a rental property in Florida if it's producing it. So we have all these sort of neat, and that's just a sampling. We have all these other neat tools. Every case is going to be unique. And when we have our consultation, we're going, okay, based on the client's feedback, we're putting together and their situation. Are they at home or are they in an assisted living facility? Is liquidity important, or is it more asset protection and protecting it for the next generation important? Or is it some combination of the two? So that's why everyone's going to be a unique case.
That's a good point, right? And I think that's something to hammer home, is everybody's a little bit unique. So it's, why it's important to sit down and understand where somebody's at, not only financially, but the type of services they're receiving or could be receiving. One caveat I did want to make is, when we talk about Medicaid, there's variety of Medicaid problems.
Yes. Programs, yeah.
Programs, yeah. And so one of those ones I know we work a lot with, not so much for you because you're more on that long-term planning, typically more elderly. One we see a lot that is tied to SSI is the iBudget Medicaid waiver, right? So that's a unique waiver. It's specifically for individuals with an intellectual or developmental disability that occur prior to, usually around childbirth. Those have a whole host of other rules that typically follow like the SSI rules when it comes to, $2,000 in assets. Now, luckily, there has been some recent legislation that has passed and that's gone to effect, which allows people to actually work more now and keep
Hmm.
that iBudget Medicaid
Yeah.
waiver.
Yeah.
So that's pretty exciting. But we're getting a lot of questions as just as it relates to able accounts. One question we have here is, stepdaughter has SSI, Medicaid, a special needs trust, an Able United account.
Mhm.
It's a lot of programs. They're carrying it on behalf of a loved one. But what happens when that individual themselves become incapacitated or pass,
Yeah.
and now they don't have somebody to manage that? Is
Yeah.
there, what do you recommend, or do you point them to another attorney that does guardianship or finding somebody to assist in that nature?
So in other words, we have a parent taking care of a special needs child, and we have all these mechanisms set up to protect their benefits, whether it's able, special needs trust, but the parent passes. How do we protect the child who is not independent
Exactly.
enough? Yeah. So very fair. So a few things we want to think about. Of course, the successor trustee and the successor authorized representative, right, through an able account or through a special needs trust. This can be perhaps a sibling or another family member that the parent trusts to be able to take care and make good financial decisions on
Hmm.
behalf of their special needs child. Sometimes we encounter people who say, listen, I just don't have other family, I don't have relatives or people that I trust. There are professional trustees, professional fiduciaries who can take over in those situations. So we have to be careful because when dealing with the um, able account, when dealing with the special needs trust, which is really just essentially paying bills, right? So operating within the bubble of an able account or a special needs trust doesn't itself require a guardianship or a guardian advocate, but doing lots of things outside of the bubble of those tools will likely require those things. So there are professional guardians for the situation where we don't have a family member who we trust enough to take over or is not available to take over. And we have to do things like who can sign a lease, who can sign the residential agreement to stay in a group home, right? You can't do that just because you're a trustee. You need someone who's either power of attorney if the disabled individual has the capacity to sign a power of attorney, or you're looking at judicially appointed powers, usually through a legal guardianship.
Wow. Yeah, a lot of things to consider, especially,
Yeah.
with an aging parent, things to consider and why it's important to reach out to somebody that understands and knows how to maneuver the system, but also can find you the resources that you need.
Sure.
So there's several questions that came about ABLE accounts, which I'll be more than happy
Yeah.
to ask. So one of the questions is, can an ABLE account owner access their funds at any time, and who is allowed to contribute directly to the account? And so ABLE accounts are unique in that it can be anybody's money that goes in, first party, third party. It is subject to $20,000 per calendar year from all sources. So definitely keep that in mind when it comes to planning. Yeah, we've seen sometimes where a special needs trust will front load the money at the beginning of the year, and then October they're like, oh, we need to make a deposit, but they've already reached their max. So a lot of just figuring out, who all can put money in and utilizing it best for your situation.
Mhm.
Um, and then we get a lot of questions about SSI, right? So, supplemental security income, there's a lot of more rules, some nuances when it comes to ABLE accounts. So one question was ABLE accounts impact on SSI.
Mhm.
Is it just the $100,000 balance? So ABLE has some unique rules when it comes to supplemental security income.
Yeah.
When it comes to, hey, if it's over 100,000, then at that time it starts counting as a resource for SSI purposes. What's supposed to happen is Social Security says, okay, we're going to, basically disable your SSI, but let you maintain your eligibility for Medicaid. That's what they say is supposed to happen, but sometimes that's not always the case. So I always recommend talking to a legal professional if that's a situation you find yourself
We have to be
in.
careful that, yeah, the rules are very specific that if the only reason why you SSI is at all being threatened is because your ABLE account goes above $100,000, then you would lose the check. You for sure lose the
Correct.
check.
Hmm.
But you keep a lot of people don't care so much about the check. They want just a dollar of SSI because with that dollar comes the full suite of Medicaid health insurance benefits. So they really just care about the health insurance. So so practically speaking, if your ABLE account has more than $100,000, you're in a pretty good situation. You're not really so dependent on the $994 check every month. You do care very much about what happens if you go to the hospital, your expensive prescriptions and things like that. That is supposed to continue. Now, I think the issue that you brought up is the caseworker on the SSA side knowledgeable about that. So that's
Exactly.
where they might need an attorney involved to, like, sort of gently set them straight a little bit and say, hey, you can take away that check. That's okay. That's appropriate. But if the only reason why you're taking away that check is because the ABLE account has too much money and their personal bank account maintains that balance below $2,000 on the first day of every
Yep.
month, then health insurance has to continue.
Yeah, that's a good point. We have a comment in here. Wanda says hi. You're her. Jason's my attorney, she
Oh,
says.
that's
So,
nice. I want it. That's great.
they got a little shout out there. So
That's
that's
great.
awesome. All right, here's a question we have. Let's talk about when it comes to retirement plans and I think you mentioned a little bit about this when it comes to your planning that Florida is very unique in
Mhm.
that for some of the Medicaid planning purposes, they don't look at some retirement accounts. Can you explain a little bit about what that means? Is it just the person? Does it include the spouse, or how does that work?
Yeah. So when Medicaid, independent of SSI, is evaluating I'll back up even one more second. There's like 12 or 13 flavors of Medicaid in the state of
Yeah.
Florida. So what I'm really only talking about is I'm really speaking about QMB, long-term Medicaid waiver, and ICP and PACE. I'm talking about these programs. So it's really if you want care at home, if you want care in a nursing facility, or if you just need help paying for expensive prescriptions and you're a Medicaid recipient. There are other programs where this doesn't apply. All right, so let's start with that. So now, when determining whether someone is or is not eligible, they're looking at, if we have a married couple, they're looking at both of their assets combined, subject to that 162,000 and change allowance of the healthy spouse, if that's relevant. But they're only looking at the individual spouse's income. So,
Okay.
in the kind of let's say we have a married couple and they both have sizable IRAs. But while we are applying, we want both of those IRAs, the IRAs from both spouses, to be paying out. If it's not required, like for example, if it's a Roth IRA, which doesn't have a required distribution, we still want to take out regular distributions because that's how we take advantage of the rule that says if you have a qualified retirement account and it's paying out regularly, the asset doesn't count. Okay, so now we have a few things. The asset doesn't count. The income that comes out of it counts. And we might need what's called a Miller trust or a qualified income trust because we're now adding up Social Security plus the distributions plus pensions, however they have money coming in. If it is above a certain amount called the income cap, we need a Miller trust for that. But we don't have to cash out of the $500,000 IRA, which is nice. Now, for the healthy, to get a little more complicated, but this is kind of neat. For the healthy spouse, we are still turning on their IRA. We're still making it distribute money while the application is pending. But once we get the sicker spouse approved, from that point forward, Medicaid does not look at the healthy spouse's assets anymore. So if we want to, after we get the sicker spouse approved, if we want to turn off the IRA distributions, we can do that. So again, a lot of nuances here, and that's why I always emphasize everyone's different. We gotta take everyone and give them
Yeah,
their unique plan. Yeah.
exactly. Ooh, here's a good question when we're talking about Medicaid is about Medicaid is state recovery. All right. I
Yes.
get there's some
Yes.
confusion on, okay, yes, we're able to
Sure.
shelter this and help them. Then they unfortunately pass away in the nursing home. Now, does the state go say, hey, all those
Yeah.
accounts that you sheltered, is that all ours or how does that work?
Yeah. We also very, very common concern.
Complex as well, right?
Yeah. Sure. Well, so we have a few principles. There are certain tools that we have to accept that there will be some Medicaid estate recovery. So, for example, in a Miller trust or qualified income trust, any funds remaining are likely going back to the state. Same thing with a first party special needs trust. Um, There are other tools like the promissory note and the personal services contract and some real estate investments where we can avoid Medicaid estate recovery, because other than those,
Okay.
other than if we're using a vehicle that has an automatic estate recovery feature that must be built in, everything else we have to abide by the principle that in Florida, if there is no probate, then there is no Medicaid estate recovery. So, for example, with that IRA we were talking about a moment ago, right? The client passes away, they're on Medicaid, there's hundreds of thousands of dollars left in that IRA. Is Medicaid going to have a claim to it? The answer is it depends. What does it depend on? Is there a pay on death beneficiary with the IRA?
Oh,
Then
okay.
it bypasses probate. The IRA knows who they're writing a check out to, right? And they said, now if there is no pay on death beneficiary, or if that pay on death beneficiary has predeceased and there's no backup, now how the IRA custodian is going to say, well, we don't know who to give the money to. Get us a judge's order. And now you have to open up a probate. And if you open up the probate, Medicaid will be alerted if you're over the age of 55. Every judge in the state of Florida is mandated to notify Medicaid if so we can avoid the probate. So that's why, again, we don't always want to rely on pay on death beneficiary designations. We might want to rely on trusts that don't have a Medicaid payback built into it, because we can now avoid probate almost no matter what. It's not guaranteed, but we're 99% sure we'll be able to avoid probate.
Awesome.
Same thing with the homestead. Well, the homestead is a little bit different, because even if that does have to go through probate, in Florida, we have such strong homestead laws that as long as it's going to a qualified heir, like it's going to essentially a relative, it can't just go to a friend. But if it's going to a qualified heir, even if you have to go through probate, Medicaid won't be able to touch it because of the strong probate rules that we have. But again, we want to avoid probate. We want to use a revocable trust or a ladybird deed to avoid all that extra hassle and expense if we can. And ABLE accounts, my understanding is Medicaid, it's sort of, the answer's like wishy-washy with ABLE accounts, right?
Exactly.
Because
Yeah.
here's my understanding. And my understanding is Medicaid doesn't submit a claim to ABLE directly. They're not able to do that. And another advantage to ABLE, which I love, is ABLE very specifically can pay for things like burial and funeral expenses and other qualified disability expenses before. Here's the wishy-washy part. If there is no family member who's also an ABLE beneficiary, then your only option is to distribute to the estate.
Correct.
And again, estate means probate court. So I think that's their back door to getting some of this stuff.
Yeah, it is very interesting just because, like to your point, you said post-death payments are allowable, right? Funeral and burial, those
Which you
types of
can't do out of
things.
a first-party trust, like to point out. So there is a benefit to that, is to say, listen, we have some final things that we got to take care of. ABLE account can take care of it. A first-party special needs trust cannot.
Exactly. And so that kind of ties in, and that's why I kind of stress when it comes to ABLE accounts and planning is really ABLE accounts are geared to be an expense account. Now, there's some legislation in the future to maybe tweak and change that, hopefully on a federal level, to make this on par with like a typical retirement account, but for people with disabilities, which we'll see where that kind of lays out, because there's still a lot of work to get done. But to your point, right, the goal of this account really is to say, hey, if it's coming from a trust to fund this account, and this is kind of their daily expenditure account, or we're saving for that trip, or personal care attendant, or whatever the case may be, it's a good point saying, hey, you know, depending on your plan, you may not want to have hundreds of $1,000s in the ABLE account. It really is to kind of be expense. Let's look at some of these questions. We already kind of talked a little bit. You kind of mentioned this and alluded to special needs trust. So high level, I don't know what this is. I never heard of a special needs trust or self-settled trust or Miller trust or these different types of trusts. Can you just give us a bird's eye view of the different kind of trusts that you work with, or individuals in this population may be familiar with?
Yeah, so there's lots of different types of trusts in this world. So from a special needs trust or supplemental needs trust perspective, there are two broad categories of SNTs. There's first party special needs trusts, there's third party special needs trusts. So first party is your money, the Medicaid, the person who's on SSI, it's their money, it's their asset. So this could be if they own a house which is in their name and they have to sell it. We have other options, but if they're going to use a special needs trust, it's going to go into a first party special needs trust. If they receive an inheritance directly and that inheritance has not been diverted into some other vehicle. We'll get into that in a moment. But if it's going into the name of the individual on SSI or on Medicaid, that money, if they want to use a special needs trust, it's a first party special needs trust. If they are receiving a personal injury or medical malpractice settlement and they want to use a special needs trust, so I'm saying because it's not, these are not the only options, but if they want to use a special needs trust, it's a first party special, it's their money. And the big deal about it being a first party special needs trust is by law, it must provide for Medicaid estate recovery. I do not have the ability, if it's first party money, I do not have the ability to draft a special needs trust without an estate recovery provision. Contrast that with a third party special needs trust. Very classically, this is a parent who wants to leave money to their child who has special needs. This is the classic, most often the case.
Yeah.
Yeah. So, well, it's mom and dad's money now. And if there's some options. If they just have a regular run of the mill will that says, I'm leaving all this money to my child individually, that's first party money. However, they don't have to do that. With good planning, they could go to an experienced elder law or estate planning attorney and say, I want a trust and I want to leave money into a special needs trust for the benefit of my disabled child. And if they do that, where the money never touches the disabled child's personal name and instead flows from mom or dad or mom and dad to a special needs trust for the benefit of that child, now it's a third party special needs trust. And why do we love that? Because there is no Medicaid payback obligation. There does not have to be a Medicaid payback because it was never the disabled child's money to begin with. Okay. So that is at a very high level, kind of the two broad categories. I mean, there's all sorts of, again, Miller trusts are just for income. We wouldn't stick assets in there. There's Medicaid asset protection trusts that really have nothing to do with what we're talking about here. There's, revocable living trusts are not providing you with asset protection. Special needs trusts are their own sort of very, as the word might suggest, special category of trusts for the purposes of maintaining or obtaining eligibility for SSI or other needs-based government benefits like Medicaid.
That's great. Well, let's go here to some more questions we're getting in through the chat here. This is an interesting question. Are there guidelines for renting, buying a house with an ABLE account? Is there a max amount? Is there a max number of times you can buy every 2 to 5 years? Do you transfer it to a trust after? So that last one question, part of the question is kind of interesting, but really, at the end of the day, the benefit of the ABLE account has to be for the person with the disability. So, they can't be buying everybody in the family a house, right? That would be, transferring a resource to somebody else and almost giving the funds away. I'm not an attorney, I'm not an IRS, but I'm assuming, hey, they're probably going to say, how's that benefiting the individual with the disability? So keep that in mind. But the idea of, do you transfer it to a trust after that? That's where it gets a little confusing. Are you talking about, hey, if we're purchasing a home for a person with a disability, should that house be in a trust so it doesn't go, do a probate or something like that? I think that's what more of that estate planning.
Yeah, if we have the ability, it depends on the capacity and what the power of attorney or the legal guardian is able to do. But yes, I am in favor of I have no problem with so let me give you an example. If we have, there's so many permutations to this, but let's say we have a first party special needs trust with a bunch of money in it. And the disabled individual is renting a place. Well, if there's enough money to cover the cost of the house and provide for the other needs of the disabled individual, I have no problem with the first party special needs trust distributing money to the disabled individual. Then they go buy a house. Because that is, it's an appreciating asset, and there's ways to sort of tap into the equity if that's needed later on. And they want a place to live, and they don't want to be at the whim of a landlord who can kick them out. I think that's a qualified disability expense, and I have no problem with the ABLE account paying for the mortgage, paying for the housing costs and things like that. But more importantly, well, not more importantly, just as importantly, we've taken a lot of money out of a trust that has a Medicaid payback obligation, we've now put it into an asset where we can structure that where there is no Medicaid payback obligation for that asset after the Medicaid recipient passes away. Isn't that nice? So
Yep.
there's all sorts of different permutations for how we can use trusts and home ownership. And since we're talking about ABLE accounts and home ownership, I think it is really important to point out another really big benefit to ABLE accounts. If this is for SSI recipients, if an SSI recipient wants any third party's help paying for shelter expenses, that's rent, mortgage, utilities, taxes, property taxes, there's a
Insurance. Yep.
insurance, exactly. If a special needs trust or a family member helps to cover those, it's a list of, I think, 7 items. It's a very
Yeah.
small list of items, but if any third party, including a special needs trust, pays for those 7 items, that's what's called an ISM expense,
Yep.
or that stands for in-kind support and maintenance, which can result in a reduction in their SSI check. So again, not Social Security retirement, not Social Security disability, but supplemental security income, SSI. This is the only thing this is relevant to. However, if they have an ABLE account, you could take the special needs trust if there's not enough money in the ABLE account, transfer money into the ABLE account. If the ABLE account pays those same exact ISM shelter expenses, there is no reduction in the SSI check.
Yeah. Yeah. It's a huge, I mean, because that ISM is a third of your reduction, right? So
Yep.
you're talking, we're at what, 996 now, I think is the SSI
Yep.
payment. So down to $600, you can be
Mhm.
an extra $300 a month, right? Who
Yeah.
couldn't use that? So,
Correct.
the only caveat there is I said, hey, don't retain on the funds past the end of the month, because that's
Yeah.
where Social Security kind of says, hey, if this is housing, you got to expense it in the same month. But the great
Right.
thing is we have online bill check pay. You just say, hey, pay the landlord directly.
Oh, I love
We
that.
actually, a little behind the scenes here, we actually rolled out a systematic distribution online now. So historically, that was a paper form that if you're, hey, I wanted to pay this rent every month, it's this amount. You had to fill out this form, but now it's all done online. So you
Mhm.
could say, hey, 5th of every month, I want you to cut a check from my ABLE account to pay my rent, my mortgage, my
That's
whatever that
great.
monthly fee is. So it's all done
That's
online
great.
now. So that's a cool
Yeah,
thing.
I'm a big proponent of that as well. My clients who have ABLE accounts, they have the ability to have the money direct deposited into their bank account and they can pay from there.
Yep,
And I
exactly.
go, you're playing with fire. I mean, you can, just because you can doesn't mean you should. There's that famous
Mm-hmm.
Jurassic Park line, right? Just because you can doesn't mean you should.
We
Right?
should. Yep.
Yeah, right.
The
So
ethics of it, right?
exactly. If you can have ABLE pay the expense directly, just do that and you don't have to worry about it anymore.
Yep, exactly. All right, let's tackle some of these other questions we have here. Um, we talked a little about state of planning and what that looks like. This is interesting, right? It's just terminology, right? Because I think when you start about all these different programs, terms change a little bit. So when
Yeah.
trusts are involved, the term successor
Mhm.
is used in lieu of a typical beneficiary term used for life insurance policies. Is that correct?
In a trust, you're typically talking about a successor trustee. So you're the
Who's
initial trustee is who can make decisions on behalf of the trust now. If that person becomes unwilling or unable or passes away to
hmm
operate the trust, who's next in line? That's the successor trustee. For a pay on death beneficiary, some accounts allow you to do very similar. Here's the primary beneficiary, and only if that primary beneficiary has predeceased, then there's a contingent, usually call it a contingent beneficiary. Here's who sort of the backup is to that person.
Good point. Good explanation of that. I appreciate it, Jason. So here's a question that talks a little bit about able to work, which is a
Mhm.
provision that allows individuals who are working and not saving for retirement to contribute above the annual contribution limit for able, which this year is 20,000. It actually lets them put an additional 15,650. I think the heart of this question is talking about trying to shelter that income.
Mhm.
Able accounts do not shelter income. So
Mhm.
keep that in mind. So even if the beneficiary is directly depositing their entire paycheck into the able account, that still counts as income
Right.
for IRS purposes. If somebody's on SSI, it's going to count for that.
Substantial gainful activity for
Yeah,
disability determination
SSDI,
purposes. Yeah.
right?
Mhm.
Exactly. So keep that in mind. Able accounts don't shelter income. And that limit of 15,650, it's based on a weird formula. It's the single household income for somebody on federal poverty limit from the prior year. I don't know who
Mm.
comes up with this
Uh-huh.
language, but they point to something. And so that's the most you can contribute. So somebody, for example, I think they said they're making 17,689. Well, they could put up to 15,650 in addition to that 20,000 into the able account, but they wouldn't be able to put the full 17,000. So it's the lesser of the two, your income or the 15,650, whatever's less.
Mhm.
Um, all right, here's a question we get a little bit about when it comes to. I know you probably don't work with children, but if you're thinking of somebody that has a loved one with a disability, they're getting to that age of being 18 and
Mhm.
they're concerned about documentation, right? I don't,
Yeah.
my child is about to turn 18. They don't have the capacity potentially to make decisions. Can I just get by with a power of attorney? Do I need to get full guardianship? And I don't know if this is all handled in your office, but what do you point to somebody that's saying, hey, my child's becoming an adult. What do I do?
Yeah.
What do I need to prepare? What documentation do I need?
So if they're disabled, the real question is what is the extent of the disability from a cognitive perspective? In other words,
Hmm.
I don't care how physically disabled somebody is, if they have their mind, then they can just sign a power of attorney once they turn 18, and that's perfectly fine. If they are cognitively disabled and they don't have the mental capacity to kind of understand what's going on around them, there is power of attorney is off the table. You're not able to sign a power of attorney. You need to have that capacity initially, and not that I don't. Again, I've worked with people who don't have arms. Right? They
Yeah.
they were in a
Yeah.
horrible accident and they can't sign. So it's not the ability to physically sign the document that I care about. Is do you understand what it is that you're signing? If the answer is no, then they're in the world of guardianship or guardian advocacy if they have a
Hmm.
developmental disability, depending on the extent of
Yeah.
their ability to make decisions.
Yeah, that's a good point.
Mhm.
So here's a question that this ties directly into you. How does a Florida Ladybird enhanced deed affect Medicaid qualification for nursing home and federal benefits, housing, etc.?
That's a great question. It does not help or hurt. So what do I mean by that? So if it's your homestead, your homestead is protected whether or not you are in a nursing home or an assisted living facility or receiving care at home. And Medicaid's not going to count that against you, subject to a few exceptions that I think are beyond the scope of this presentation. So a ladybird deed is preferred, or revocable trust is preferred to a standard life estate, because in a ladybird deed situation, you retain 100% ownership. That's why it's called an enhanced life estate. In a standard or traditional life estate deed, you are actually transferring an equity interest in your home to somebody else. You're keeping some equity, you're giving someone else equity as well. They have rights. And if you do that, that's a potential problem because gifting is still not allowed. But with a ladybird
Okay.
deed, there's no gift happening because you retain 100% control. You retain the ability to change your mind and say, these are not the people I want to inherit this home after I pass away. And as a result, you will maintain eligibility. Now, if you sell the property, you now have a problem you have to deal with. It's not an insurmountable problem. If you sell the property, you're taking a protected asset, you're converting it into cash, which is not a protected asset. We have work to do. Whether it's subject to a ladybird deed or not doesn't help or hurt. Ladybird doesn't help that, but it helps avoid probate. It doesn't negatively impact Medicaid eligibility.
Great. Here's a question, kind of switching topics back to Social Security. I know we're bouncing all over the place
Sure.
here,
Right.
but individuals are like high level
Yeah.
SSI,
Yeah.
SSDI,
Yeah.
regular Social Security. What are the differences?
Yeah. Is actually one of my more popular YouTube videos because there's a lot of people. I do a lot of YouTube videos trying to like educate people,
Yeah.
and this is one of my big ones. And the reason is, so a lot of people will go, "I'm on disability." I go,
Yeah.
I don't know what that means because there's Social Security Disability Insurance, that's SSDI, and there's Supplemental Security Income, which is SSI. Those are two different programs. You can have one, the other, or both.
Mhm.
What's the difference? SSDI is based on your work record or the work record of maybe a parent. Okay, you've paid into the system. You're like paying for this insurance policy through the federal government. And if you become unable to work before turning 65, and if you've paid sufficient quarters into the system, you get this check. And that check you get it because you're disabled. You get it because you're unable to work. You meet Social Security's definition of disabled, you're unable to work. And that does not automatically give you Medicaid. And the government who's paying you the SSDI check doesn't care how much money you have in the bank. You could have nothing in the bank. You could have $1 million in the bank and you're still getting the same SSDI check every month. It's not a means tested program. And after 2 years on SSDI, you get Medicare, not Medicaid. SSI, on the other hand, is a needs-based program. If you have not worked sufficient quarters and you are either disabled, over the age of 18 and disabled, or you're over the age of 65 and your income is lower than 994, maybe 996. I don't remember the exact number. It's right.
It's right there. 996, I think.
996. Okay, 996. So if you make more than $996 from another source of income, whether it's a pension or whether it's IRA distributions or whether it's through anything, passive or active income, you're not entitled to SSI. You cannot make more than, they have what's called a $20 disregard. I'm not getting into that, but if you make more than, essentially, if you make more than $996 a month, you cannot get SSI. Doesn't matter what type of trust you have. There's no Miller trust. There's no income trust. It's just, if you get it, if you get more. So if a client comes to me and says, I'm on disability, but they're not sure if they're on SSDI or SSI, one quick test is if they say, I go, well, how much money are you receiving per month? If they say, well, I'm receiving $1,200 a month. I go, okay, you're not on SSI, but you can't. That's impossible. You can't have SSI and receive $1,200 a month. Correct. Right. Correct. So with SSI, you automatically get Medicaid. Now, some people have both. If you didn't work enough, your check might be the amount, the SSDI check. If your SSDI check is, I'm going to use a round number, $500 per month, you might also have SSI that would bring you up to the $996. Okay, so that check would be $496, right? So SSDI plus SSI together is only getting you up to that SSI max of $996. Okay, and so you can have both, and there you might have Medicare and Medicaid, and then if you were coming into money, your SSDI and Medicare is not at risk, but your SSI and Medicaid is, and the question is, how much money are you coming into? Is it worth it? Do you want to protect the Medicaid? And the answer to that question might be yes or no. If the answer is yes, we have ways of dealing with that.
Thank you for that. And for let the record show, never question your attorney. It was 994 is the correct amount, not 96.
Okay,
so Jason did his homework. I was like, I have my cheat sheet here, and I'm like, oh wait, nope, it was 994.
Good. Okay.
So good for you. Here's a good question, right? So I think they said on average, Florida experiences like close to 1,000 new residents a day here in the state, which is kind of mind-boggling. So sister lives in New Jersey. Her caregiver passed away. I have a POA. She has a special needs trust, and I want to move her to Florida. You know, do I have to open up a new trust? Do I have to get a new POA? How does it work when you're talking about one state and their rules and moving into Florida?
So if the individual is on SSI, then they will automatically be entitled to Medicaid in Florida if they move from out of state into Florida. If they're not on SSI, but they're on another non-SSI dependent Medicaid program in that other state, Medicaid does not automatically transfer. They have to reapply. And some of these programs have a wait list and others don't. And there's an application process. As far as the power of attorney is concerned, the Florida law says that if the power of attorney was valid in that other state, if you could do it in that other state, we will honor it here.
Okay.
Practically speaking, though, I tell people if you're moving to Florida and you're going to be here for a good long while, you're not just visiting, but you're going to be here, this is going to be your new residence. Why not get good Florida documents? Because while you can technically get, so I have clients who come to me who don't have capacity and I'm presented with an out-of-state power of attorney. What I have to do is I have to get a letter from an attorney in that other state to say this was validly executed per the laws of the state of New Jersey. And this allows the agent to do, and I list the things that I need it to do because they're not all created equally. Some powers of attorney let you do X and Y, but not Z. And Z might be really important. So if my client has the ability, even if it's perfectly a good document in that other state, why set up a barrier for yourself, right? If you go to the bank and the teller is not used to seeing this out-of-state power of attorney, now you got to go through this whole rigmarole of getting this letter from another and dealing with legal counsel. It's like, just if you can get good Florida documents, it's going to save you a headache down the road. But if you don't, we'll have to take some Tylenol and we'll be on our way. We'll make it happen. Yeah.
I'm just looking through some of the questions here that relate to our discussion. Question on moving excess SSI money into the ABLE account, right? That's another thing that's beneficial with the ABLE account. Yeah, it can maintain your
Sure.
remaining SSI or SSDI, whatever Social Security you live, but it is subject to that $20,000 threshold, so keep that in mind. Just looking through some
I
of
like people to
the
know that with SSI, different than separate state Medicaid, SSI cares about how much money you have on the first day of the calendar month. Non-SSI Medicaid in Florida just says one day, if you're below $2,000, you're good, or whatever the threshold is. There are programs that have higher thresholds, but for SSI, it's the first day of the calendar month. So if you're at the end of the month, if you have an ABLE account, you're end of the month, if you have $2,005 and you haven't already committed 20 grand to the account, throw $5 in there so that you don't have to worry about it, right? So
exactly.
mhm.
Yeah. It's that main idea. The first of the month, we get a lot of questions, and people think, "Oh, I escaped by this month; they didn't catch it." Well, Social Security isn't reviewing these sometimes
Yes,
monthly. They
yeah,
usually do an annual review, and at those
yeah.
points, they're wanting
And I think they're also
documentations
usually
and
about 2 or 3 months
questions.
behind in terms of reviewing
Hmm.
what's going on with that month if they're going to be reviewing it. Yeah.
All right. Just going back up to the top of some of these questions. Let's look at some of the questions that were sent to us ahead of time. Um, Petitioning the court when it comes to guardianship. We won't dig too much into that. I know that's not your lane of expertise. Let's talk a little bit about someone on Medicaid sells their home and moves into an ALF. What happens to the proceeds of that home?
Uh, okay.
That's a good
So
question.
yes, good question. So someone needs care in an assisted living facility or a nursing facility. We have some choices to make. Um, they can still own their homestead. They don't have to sell it. Let's start with that basis. So the issue is though, who's paying the upkeep of the house? Who's paying the property taxes? And if there's an HOA and insurance, and you got to keep the air conditioning running so mold doesn't build up, right? So there's still operating expenses for even an empty house. So if you have money set aside in an ABLE account or a special needs trust, or a family member is going to inherit the house, has the ability to carry the home, you might decide to do that. Another option is if you're not concerned about SSI, but you just are really more concerned about Medicaid waiver to pay for a portion of that assisted living facility, or essentially nearly all of the nursing facility bill, you can rent out the house. And there's ways to do that where you can benefit from that additional, but my client, the Medicaid recipient, can benefit from that additional income. And now the house is productive. And again, the children or whoever is inheriting this appreciating asset. But that's of course being a landlord, it's a pain in the butt, and very very rationally people might go, I don't want to rent it out. I just want to sell it and be done with it. If they want to sell it, we need to have a conversation about, okay, before you receive these proceeds, what are we going to do? And it's a
Hmm.
combination of, any of a half a dozen different strategies that we're going to move this money in a way that's not going to jeopardize my client's ability to remain or become eligible for Medicaid.
That's great. I know we got about 5 minutes left, so we'll throw a softball one here.
Yeah,
High level when we talk about just planning, right? Planning, estate planning for the
yeah,
future. High level, what's the difference between a will and a trust?
yes, very good. So Very good question, because a lot of people feel this great sense of accomplishment when they sign a will. And a will might be, it might be 5 pages long, might be 40 pages long. It looks very official. You've gone into your attorney's office. There's been two witnesses. There's a notary. It feels like it might be in like big cursive letters, and it feels like a very official document. And people will sometimes very confidently say, Jason, I don't have to worry about probate. I signed my will. And I go, I'm so sorry. I go, if you're relying on a will, the will doesn't do anything for anybody until you pass away and present it to a judge. So that means a will, when you're reliant on a will, that is a one-way ticket to probate court. Okay? Only judges get to read wills. You don't get to go to your son can't go to the bank and say, hey, all of this is coming to me. Here, bank, give me the money. They're going to go, well, there's no pay on death beneficiary, and I don't have a judge's order. That will is useless to me without a judge's order. Okay. Go take that to a judge and come back to me when you have a judge's order. All right. If we want to avoid probate and we want to provide some additional protections for the people who are going to inherit the money, the tool of choice is a revocable living trust. Sometimes you'll hear it referred to as a revocable trust. Sometimes you hear it referred to as a living trust, but those are all terms that mean the exact same thing. And those are tools where we get to do things like, here's who gets, because a revocable living trust lives on even after the grantor or the person who created the trust passes away. It continues into being. And essentially, a revocable living trust is a set of instructions. You get to change the instructions as long as you're capable of doing so. But once you pass away, they become set in stone, because a revocable trust becomes irrevocable the moment the grantor passes away. And we also have some of the instructions are, well, I'm in charge while I'm alive, but here's who's in charge when I pass away. The successor trustee. We talked about that a few moments ago. The successor trustee immediately gets to go and say, okay, what does this trust say? Who gets these assets? What happens if someone who was supposed to get the assets themselves has passed away? Well, we have built-in contingency plans in our revocable living trust. What if we want to provide money to a child who has a gambling problem or an addiction problem or we're afraid they're going to get divorced problem, and we don't want to just write them a check for their share of the trust? Well, we have things that we can do in a revocable living trust that keep the money there for their benefit, but not have it susceptible to a lot of these outside threats. Right? So you do a lot more interesting things with a revocable living trust compared to a will. You get to avoid court, and you get to provide for all these sort of different levels of protection and contingencies, and sort of ensure that the court process is avoided.
That's great, Jason. I know we're kind of wrapping up here on time. And so thank you once again so much for the opportunity for you to come on to share your wealth of knowledge. I know there's a ton of material on your YouTube website, on your where can people get a hold of you? I know Elder Needs Law, is that still a good website for
Elder
you?
Needs Law, elderneedslaw.com is all our numbers are there, and I have we serve all of Florida. We have 4 physical offices. We serve all of Florida remotely, and our central line is 305-912-5768. I see people in Aventura, Plantation, or Boca Raton offices. I have a partner who's in Spring Hill, which is right outside of Tampa. And then again, statewide, if you're comfortable doing it like this over Zoom.
Awesome. That's a great way. So other ways to find people in your field. So maybe they're more interested in guardianship.
Yeah, totally.
Where do you point people to say, hey, where do I go if I want to find somebody locally?
Yeah, I think I love the National Academy of Elder Law Attorneys. That's NAELA, NAELA.org. And there's a very prominently placed find an attorney. You can put in your zip code, and you'll get a list of attorneys who are nearby that zip code. And you can see, are they board certified or not? You can see what do they practice in? Not all elder law attorneys are the same. I focus on Medicaid planning, special needs planning, estate planning, and probate. I don't do so much guardianship. I refer that out to other attorneys. And other attorneys are different, right? They do other things. So yeah, absolutely. That's a great resource.
Awesome. Well, once again, thank you so much for your time. I know if you're listening and paying attention this time, if you did attend, we will be sending out certificates. If you check hey, I need a certificate to show that I completed this course. Hopefully the information was just as valuable for you as it was for me. I know I always learn a lot during these interviews and webinars. So Jason, I know knowledge is power. I just appreciate your willingness to share some of that knowledge with us. But any final words from you?
Yeah, I'd say I echo what you're saying. Knowledge really is power. There's a lot of bad information on the
Mhm.
internet, and people get their information from their neighbor, and that's where people lose out on a lot of potential benefits. And so, speaking to a qualified professional, even if it's not me, I promise that's okay. Talk to somebody who knows what they're doing and has
Yep.
experience, so that you can get really specific guidance. Because the guidance, even the guidance I'm providing to people, in these sorts of webinars, your situation might be a little bit different. So you need that personalized attention to make sure you're not jeopardizing benefits and you're protecting your loved ones.
Awesome. Well, thank you all for attending today. Appreciate it. And we'll be getting this information out. If you haven't seen, we will be posting this recording on our YouTube channel, Able United, or youtube.com/Able United, and you'll learn. You can rewatch it, get some more details, and appreciate the time once again, Jason, for your time. But I know we'll be probably running into each other at one of these conferences here
Always.
sooner than later. Uh, Thank you all. Thank you all for our interpretation services as well. They did a lovely job. I don't know how they keep up with all this, but appreciate you as well. And hope you all have a wonderful rest of your afternoon.
Thank you.
Thank you.